Hello, and welcome to this CLE program. My name is Ben Morris, and I'm the Florida Bar Program Administrator for the Admiralty and Maritime Law Committee. Due to some technical issues at the beginning of this program, we'll be joining the first of three speakers, Walter Cooper Jarnigan, after he was introduced by Committee Chair Thomas Graham. Because Mr. Jarnigan's introduction wasn't captured on this recording, I wanted to make sure he was properly recognized. Walter Cooper Jarnigan, known to many as Cooper, is a Florida Bar board-certified Admiralty and Maritime lawyer who focuses his practice on Admiralty claims and litigation. He represents the world's largest cruise lines in high-exposure maritime passenger and crew member claims alleging medical malpractice, sexual assault, overservice, wrongful death, unsafe workplace, deficient program provision of maintenance and cure, and personal injury. Cooper also has experience in the recreational marine sector, handling property damage and personal injury claims. This includes litigating limitation of liability actions on behalf of vessel owners, providing counsel in marine insurance coverage matters, and defending vessel repairs in breach of warranty actions. Again, we join Mr. Jarnigan's presentation already in progress. Thank you.
Sufficiency, you properly allege maritime negligence. So if defense counsel files a motion to dismiss, it's going to be subject to the federal rules of civil procedure as to whether, the complaint is sufficiently pled, whether the claim is plausibly pled. And as you'll see, if the complaint is difficult to discern based on the form or the substance of the complaint, it may be dismissed as a shotgun pleading. Now, just going over briefly the federal rules that apply to these types of motions to dismiss. Federal Rule of Civil Procedure 8 requires a short and plain statement. Oh, 1 second, let me pull up the presentation. Okay. Federal Rule of Civil Procedure 8 requires a short and plain statement for the jurisdiction, short and plain statement of the claim, and then a demand for the relief sought by the plaintiff. Under Federal Rule of Civil Procedure 10, in particular, subsection B, paragraphs, a party must state its claims or defenses in numbered paragraph, each limited as far as practical to a single set of circumstances. A pleading may refer by number to a paragraph in an earlier proceeding, and each claim must be founded on a separate transaction or occurrence. And this includes affirmative defenses and denials, and they must be stated in a separate count or defense. So this is going to come up later when we look at how courts review shotgun pleadings. Federal Rule of Civil Procedure 12b6 governs whether a plaintiff has properly stated a claim. And it looks at Rule 8, and a court, when they receive your complaint is going to see if the complaint is plausible on its face. So the court is going to read your complaint as if all your allegations are true, and it's going to assess whether you've stated enough facts in order to plausibly state a claim for maritime negligence. But where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, you haven't pled properly and you haven't crossed that line from possible to plausible. Now, the first 11th Circuit case that really took a look at a plaintiff pleading both direct negligence and vicarious liability against a cruise line was Holland v. Carnival Corp, cited in 2022. In that particular case, a cruise passenger alleged that he slipped and fell on a wet substance while descending a glass staircase. And this is a very, very typical type of claim that's filed in federal court against a cruise line. And as part of the amended complaint, the plaintiff titled his claims as a vicarious liability claim for negligent maintenance and a vicarious liability claim for negligent failure to warn. So even though the plaintiff had pled his counts as vicarious liability claims, he included within those claims allegations of direct negligence because he included allegations of actual constructive notice. So plaintiff alleged that Carnival had actual or constructive knowledge of the hazardous condition because its crew members failed to conduct sufficient routine inspections of the area and failed to maintain the glass stairs in a reasonably safe condition. And as part of the negligent failure to warn claim, it claimed that Carnival had knowledge based on its failure to post appropriate signs, markings, written or oral warnings. So even though vicarious liability does not require any type of evidence of actual or constructive notice, the plaintiff in this case had pled that as part of his vicarious liability claim. Carnival filed a motion to dismiss, stating that plaintiff failed to present adequate evidence of an actual or constructive notice of a risk-creating condition, and argued that plaintiff's conclusory allegations as to whether Carnival had notice of the specific hazard, the puddle on the staircase, was insufficient to impute notice to it. So at the district court level, the motion to dismiss was granted, and Judge Stola found that the plaintiff had failed to allege that Carnival was on actual or constructive notice of the hazard in question, and the factual allegations failed to satisfy pleading standards under Twombly. Held that plaintiff failed to provide any facts in support of the allegation that there were frequent prior slip and fall incidents on this specific glass staircase. When it went up to the 11th Circuit, they affirmed dismissal of the complaint. And in doing so, the 11th Circuit cited the pleading standards in Iqbal and Twombly, specifically that the plausibility standard is not akin to a probability requirement. The analysis is not formulaic, and in determining whether a complaint states a plausible claim for relief is a context-specific task that requires the court to draw on its judicial experience and common sense. So it's giving the district court some deference to see, in the judicial court's experience, are these allegations actually going to cross the line from possible to plausible? And are the factual allegations merely threadbare recitals of the elements of the cause of action? Are they just conclusory statements to, state the elements of the claim? You need more factual allegations. And so the 11th Circuit counseled that when the district court first reviews the complaint, it eliminates any allegations that are merely legal conclusions. So in reviewing the facts of Holland specifically, the 11th Circuit distinguished a claim based on a ship owner's direct liability for its own negligence versus a claim on a ship owner's liability for another's negligence. It stated these two liability theories are very different concepts, and Holland here improperly tried to blend them into a single theory of liability against Carnival. It lays out the standard for direct liability against the ship owner itself. And that, of course, is that the defendant, the ship owner, has a duty to protect the plaintiff from a particular injury, that the ship owner breached that duty, that the breach proximately caused the injury, that the plaintiff suffered actual harm. And with respect to direct negligence against the ship owner, within the maritime context, the ship owner owes a duty of reasonable care. That reasonable care standard requires, as a prerequisite to imposing liability, that the ship owner have actual or constructive notice of the risk-creating condition. The risk-creating condition is normally the puddle of water, the step, or the improperly maintained threshold. Thus, a ship owner's actual or constructive knowledge of that condition arises as part of the duty element. So you have to allege the ship owner's actual or constructive notice of the risk-creating condition as part of your complaint. In contrast, vicarious liability. This is imputed to a ship owner whether the ship owner is at fault or not. So when the tortfeasor is an employee, the principle of vicarious liability allows the ship owner who is not at fault to be held liable for the negligent actions of its employee and that employee's scope of employment. Now, in reading the allegations in the Holland complaint, the 11th Circuit found that despite the two counts being titled vicarious liability claims, there was nothing within those counts that led them to understand the claims as such. That's because the plan did not identify any specific crew member that caused his injury. And at the same time, plaintiff inconsistently alleged that Carnival had actual constructive notice, which is not at all relevant to vicarious liability. So once the 11th Circuit decided that what plaintiff had actually done was the direct liability claims against the ship owner, it analyzed whether there were sufficient facts regarding the ship owner's actual or constructive notice. On the appeal, the plaintiff conceded that it did not allege any actual notice, so the 11th Circuit addressed only constructive notice. In regards to constructive notice, that can be established by alleging that the defective condition existed for a sufficient period of time to invite corrective measures. You can also allege constructive notice by putting forth evidence of substantially similar incidents that occurred prior to the plaintiff's incident. In Holland, plaintiff failed to allege facts that cross the line from possible to plausible regarding constructive notice. Regarding substantially similar prior incidents, plaintiff simply alleged that there were frequently spills on the staircase and prior slip and fall incidents on the staircase. But the 11th Circuit found that this was not enough. It found that these allegations were insufficient and conclusory, and that plaintiff failed to allege any facts regarding specific substantially similar prior incidents. On the other hand, the court also reviewed to see if the plaintiff had alleged whether the condition existed for a sufficient period of time to invite corrective measures. In that regard, the court said that the inferential leap from Holland's premise that the stairs were highly visible and well trodden to the ultimate conclusion that the hazard existed for a sufficient length of time was too great, and that Holland's admitted complaint lacked any allegation as to how long the slippery transient foreign substance existed, so no allegations regarding how long that puddle of water existed in the area, and no factual allegations describing the substance that would lead one to believe that that puddle of water had been there for a sufficient period of time. Now, the 11th Circuit also addressed the USCO case that I discussed earlier. And it said, in analyzing the plaintiff's negligence claim, which was brought under a theory of vicarious liability in USCO, we held that a passenger need not establish that a ship owner have actual or constructive notice of a risk-creating condition. But USCO also reaffirmed that whereas here, a plaintiff is relying on a theory of direct liability for maintaining dangerous premises or failing to warn of dangerous conditions, plaintiff must establish notice as part of those claims. Went on to say that this type of case in Holland, where the plaintiff was alleging a puddle of water on a staircase, is one where the plaintiff is limited to a theory of direct liability. And unlike the plaintiff in USCO, Holland did not identify any specific crew member that eventually caused the injury. So in USCO, you have the dancing crew member that drops the passenger, but in Holland, you simply have a puddle of water on a staircase. The 11th Circuit stated that nothing in USCO suggests that Holland could avoid pleading the required elements for direct liability, which includes actual or constructive notice, simply by titling his claims as vicarious liability claims.
Oh,
Now, following the Holland case,
yeah.
the district courts started reviewing the allegations to see if actual or
One day at a time.
properly alleged and how vicarious liability comes into play. So one such case is Kendall v. Carnival Corp. And in that case, a plaintiff alleged that he tripped over an unmarked, uneven, and unexpected change in elevation along the floor surface on deck one of the ship. And the plaintiff there.
I'm gonna start.
Which included negligent maintenance, negligent failure to correct a known dangerous condition, failure to warn of that condition, and negligent design. So Carnival moved to dismiss the complaint, arguing that the complaint did not sufficiently allege facts that show that Carnival was on actual or constructive notice of this unmarked, uneven, and unexpected change in elevation. And as part of the plaintiff's complaint in that case, it was alleged that there were 6 prior trip and fall incidents involving similar changes in elevation. That conclusively, the dangerous condition existed for such an extended time that Carnival should have known of it, and that Carnival violated industry standards relating to similar passenger walkways. So breaking those allegations of actual constructive notice down, as part of the complaint, there are 6 prior trip and fall incidents listed. And here in bold, we have an example of one. So it was alleged that in 2017, a cruise passenger tripped and fell on an uneven or sloped carpeted passenger hallway on the Sunshine. And then reviewing whether plaintiff properly alleged this prior substantially similar incident to overcome the constructive notice, the court said without any specific factual allegations, the court cannot conclude that any of these incidents were substantially similar to this case. First, only one of the prior incidents occurred on the actual vessel. And while that earlier incident occurred on a carpeted surface, there were no other facts to demonstrate that this incident was substantially similar to the one in this case. And then the court listed out a list of questions it had regarding this prior incident that was alleged. Was the dangerous condition similar or same to the one here? Where and how did the prior accident occur? Were there warnings about the change in slope in that prior accident? Did that prior accident occur in a high traffic area? Are there any precautionary actions taken by the defendant in that prior incident? And the list goes on. Now, the other allegation of constructive notice in that case was simply that the condition existed for such a length of time, and that we should have known about it because the condition was in a high traffic area of the ship. And the court said typically this is an argument that's reserved for a transitory substance case. So again, that would be a puddle of water on the floor. But the court said assuming such a theory is proper, the plaintiff has to demonstrate again specific facts regarding how long the dangerous condition existed and basically list out some type of time reference about it. Now, the third allegation of constructive notice was that the condition violated industry standards. The court said the violation of industry standards itself does not constitute notice of a dangerous condition, citing to another case, Francis v. MSC Cruises, and that the complaint here failed to identify which industry standards were violated, how and when the defendant violated them, and what relation to the industry standards this dangerous condition had. So that. Oh.
Can you hear us on the Zoom again?
Yep.
Yes.
Okay, thanks.
All
The
right,
internet went out momentarily. Sorry about that. Cooper, if you want to
yeah.
back it up 30 seconds and.
All right.
Oh, and also, if you're participating via Zoom, could you please mute yourself? We've been a couple of times, people weren't on mute. If you can mute yourself, thanks.
The sound went off when he was saying the third allegation.
Thank you.
Okay. All right, hopefully everyone can hear me and we're back. So just to rewind a little bit, I was discussing the third allegation of constructive notice, which was that defendant had constructive notice of a dangerous condition because of violation of industry standards. So the district court in Kendall said that the violation of industry standards alone does not in and of itself establish a notice of a dangerous condition. That's because the plaintiff failed to identify which industry standards were allegedly violated, how and when the defendant violated them, and what relation these industry standards actually had to the dangerous condition in that case. So in Kendall v. Carnival Court, the district court dismissed that complaint. Now, turning to Spots v. Carnival, this is an example of actual or constructive notice being adequately pled. In Spots, the passenger alleged that he slipped and fell while walking on the Lido deck of a ship, and 5 claims were brought against Carnival, all direct liability claims for negligent maintenance, failure to warn, supervision, negligent design, and training. And in that particular case, the plaintiff alleged facts and said there existed a large puddle of water, 2 feet by 25 feet, that had accumulated and remained on the deck throughout the day. The court found adequate allegations of constructive notice. In that complaint, the plaintiff cited 2 prior lawsuits involving slip and falls on the Lido deck of the ship Pride. And in that case, Judge Altman said that the plaintiff's allegations of substantially similar incidents were sufficient. And I haven't listed all the prior incidents, in this PowerPoint presentation, but there was a good description of what had occurred in those prior incidents, and there are also citations to prior lawsuits. So that gives the court some assurance that there is actual prior incidents which are going to put Carnival on constructive notice. So turning to a case with a different factual pattern, Rosenberg v. NCL Bahamas. A passenger on board a ship alleged that he was using a sauna when a jet of steam struck his arm and burned him and caused him to start to fall backwards. He alleged that he sustained some burns on his arm, that he injured his wrist. And counts were brought against the defendants for failure to inspect, maintain, and service the sauna, and for failure to warn of the sauna's condition. And in that case, the defendants moved to dismiss because plaintiff failed to allege any facts to support how they were actually on notice of this dangerous condition with the sauna. In addressing those allegations, the court said, where a plaintiff's pleading could be interchangeably alleged against any cruise line defendant, the plaintiff has failed to adequately state a claim. So you can tell from the outset that this complaint likely did not have any factual allegations regarding actual or constructive notice of the dangerous condition of the sauna. The complaint provided no details that defendants knew or should have known of any malfunction. And the plaintiff provides absolutely no details of complaints or facts specific to the ship, the ship's crew, or even the defendants in support of his allegations. And you can't simply say that there were prior incidents or complaints without backing it up with actual factual allegations regarding those prior incidents or complaints. And also, the plaintiff argued in response to the motion to dismiss that his own allegations regarding his specific incident were enough to put the defendants on notice, which the court said was improper. As part of that complaint, there was also vicarious liability claims alleged, and the court cited to Holland and said that not only does the plaintiff fail to identify any specific crew member whose negligence caused his sauna injury, he fails to specifically allege any negligence by any NCL employee at all. So there, a plaintiff could not avoid pleading elements necessary for direct liability for negligent maintenance and failure to warn by again titling his claims as vicarious liability claims and simply asserting that the defendants are vicariously liable without any evidence of actual or constructive notice. Right. So turning to another recent case, Jones v. Carnival Corporation. In that case, the passenger was returning to the cruise ship after going to Grand Cayman for the day. He was returning via tender vessel. It was alleged that the weather started to become windy and rainy with the sea being stormy. And while disembarking the tender gangway to get back onto the cruise ship, the plaintiff slipped and fell backwards. And there the plaintiff asserted 4 counts: general negligence, negligent maintenance, negligent failure to warn, and vicarious liability. And the cruise line again moved to dismiss the claims. Now, in that particular case, the court found that direct and vicarious liability claims had properly been pled separately. But the factual allegations for the direct liability claims and vicarious liability claims were identical. So the court said the true dispute was whether the underlying factual allegations supported both direct and vicarious liability claims. Plaintiff argued that defendant was directly liable as a ship owner for its failure to prevent the gangway from becoming slippery, and also that it was vicariously liable for the crew members' failure to reasonably set and secure the gangway. So the Jones court held that these direct liability and vicarious liability counts were duplicative. And that was because contrary to the plaintiff's representations, the crew member's breach of duty is premised on the same factual allegations that, accepted as true, give rise to defendant's direct liability. Specifically, the complaint alleged that defendants and its crew members breached their respective duties by engaging in 6 identical acts or omissions. So here comes the tension. Defendant is a corporate entity, and since an entity like defendant must almost act exclusively through its agents, the crew members' acts and omissions and defendant's acts are one and the same. Federal Rule of Civil Procedure 8 requires a short and plain statement for the jurisdiction, short and plain statement of the claim, and then a demand for the relief sought by the plaintiff. Under Federal Rule of Civil Procedure 10, in particular, subsection B, paragraphs, a party must state its claims or defenses in a numbered paragraph, each limited as far as practicable to a single set of circumstances. A pleading may refer by number to a paragraph in an earlier proceeding, and each claim must be founded on a separate transaction or occurrence. And this includes affirmative defenses and denials, and they must be stated in a separate count or defense. So this is going to come up later when we look at how courts review shotgun pleadings. Federal Rule of Civil Procedure 12b6 governs whether a plaintiff has properly stated a claim. And it looks at Rule 8, and a court, when they receive your complaint is going to see if the complaint is plausible on its face. So the court is going to read your complaint as if all your allegations are true, and it's going to assess whether you've stated enough facts in order to plausibly state a claim for maritime negligence. But where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, you haven't pled properly and you haven't crossed that line from possible to plausible. Now, the first 11th Circuit case that really took a look at a plaintiff pleading both direct negligence and vicarious liability against a cruise line was Holland v. Carnival Port, cited in 2022. In that particular case, a cruise passenger alleged that he slipped and fell on a wet substance while descending a glass staircase. And this is a very, very typical type of claim that's filed in federal court against a cruise line. And as part of the amended complaint, the plaintiff titled his claims as a vicarious liability claim for negligent maintenance and a vicarious liability claim for negligent failure to warn. So even though the plaintiff had pled his counts as vicarious liability claims, he included within those claims allegations of direct negligence because he included allegations of actual or constructive notice. So plaintiff alleged that Carnival had actual or constructive knowledge of the hazardous condition because its crew members failed to conduct sufficient routine inspections of the area and failed to maintain the glass stairs in a reasonably safe condition. And as part of the negligent failure to warn claim, it claimed that Carnival had knowledge based on its failure to post appropriate signs, markings, written or oral warnings. So even though vicarious liability does not require any type of evidence of actual or constructive notice, the plaintiff in this case had pled that as part of his vicarious liability claim. Carnival filed a motion to dismiss, stating that plaintiff failed to present adequate evidence of an actual or constructive notice of a risk-creating condition, and argued that plaintiff's conclusory allegations as to whether Carnival had notice of the specific hazard, the puddle on the staircase, was insufficient to impute notice to it. So the district court level, the motion to dismiss was granted, and Judge Stola found that the plaintiff had failed to allege that Carnival was on actual or constructive notice of the hazard in question, and the factual allegations failed to satisfy pleading standards under Twombly. Held that plaintiff failed to provide any facts in support of the allegation that there were frequent prior slip and fall incidents on this specific glass staircase. When it went up to the 11th Circuit, they affirmed dismissal of the complaint. And in doing so, the 11th Circuit cited the pleading standards in Iqbal and Twombly, specifically that the plausibility standard is not akin to a probability requirement. The analysis is not formulaic, and in determining whether a complaint states a plausible claim for relief is a context-specific task that requires the court to draw on its judicial experience and common sense. So it's giving the district court some deference to see, you know, in the judicial court's experience, are these allegations actually going to cross the line from possible to plausible? And are the factual allegations merely threadbare recitals of the elements of the cause of action? Are they just conclusory statements to, you know, state the elements of the claim? You need more factual allegations. And so the 11th Circuit counseled that when a district court first reviews the complaint, it eliminates any allegations that are merely legal conclusions. So in reviewing the facts of Holland specifically, the 11th Circuit distinguished a claim based on a ship owner's direct liability for its own negligence versus a claim on a ship owner's liability for another's negligence. It stated these two liability theories are very different concepts, and Holland here improperly tried to blend them into a single theory of liability against Carnival. It lays out the standard for direct liability against the ship owner itself. And that, of course, is that the defendant, the ship owner, has a duty to protect the plaintiff from a particular injury, that the ship owner breached that duty, that the breach proximately caused the injury, that the plaintiff suffered actual harm. And with respect to direct negligence against the ship owner, within the maritime context, the ship owner owes a duty of reasonable care. That reasonable care standard requires, as a prerequisite to imposing liability, that the ship owner have actual or constructive notice of the risk-creating condition. The risk-creating condition is normally the puddle of water, the step, or the improperly maintained threshold. Thus, a ship owner's actual or constructive knowledge of that condition arises as part of the duty element. So you have to allege the ship owner's actual or constructive notice of the risk-creating condition as part of your complaint. In contrast, vicarious liability. This is imputed to a ship owner whether the ship owner is at fault or not. So when the tortfeasor is an employee, the principle of vicarious liability allows the ship owner who is not at fault to be held liable for the negligent actions of its employee and that employee's scope of employment. Now, in reading the allegations in the Holland complaint, the 11th Circuit found that despite the two counts being titled vicarious liability claims, there was nothing within those counts that led them to understand the claims as such. That's because the plaintiff did not identify any specific crew member that caused his injury. And at the same time, plaintiff inconsistently alleged that Carnival had actual constructive notice, which is not at all relevant to vicarious liability. So once the 11th Circuit decided that what plaintiff had actually done was lead direct liability claims against the ship owner, it analyzed whether there were sufficient facts regarding the ship owner's actual or constructive notice. On the appeal, the plaintiff conceded that it did not allege any actual notice, so the 11th Circuit addressed only constructive notice. In regards to constructive notice, that can be established by alleging that the defective condition existed for a sufficient period of time to invite corrective measures. You can also allege constructive notice by putting forth evidence of substantially similar incidents that occurred prior to the plaintiff's incident. In Holland, plaintiff failed to allege facts that cross the line from possible to plausible regarding constructive notice. Regarding substantially similar prior incidents, plaintiff simply alleged that there were frequently spills on the staircase and prior slip and fall incidents on the staircase. But the 11th Circuit found that this was not enough. It found that these allegations were insufficient and conclusory, and that plaintiff failed to allege any facts regarding specific substantially similar prior incidents. On the other hand, the court also reviewed to see if the plaintiff had alleged whether the condition existed for a sufficient period of time to invite corrective measures. In that regard, the court said that the inferential leap from Holland's premise that the stairs were highly visible and well trodden to the ultimate conclusion that the hazard existed for a sufficient length of time was too great, and that Holland's admitted complaint lacked any allegation as to how long the slippery transient foreign substance existed. So no allegations regarding how long that puddle of water existed in the area, and no factual allegations describing the substance that would lead one to believe that that puddle of water had been there for a sufficient period of time. Now, the 11th Circuit also addressed the USCO case that I discussed earlier. And it said, in analyzing the plaintiff's negligence claim, which was brought under a theory of vicarious liability in USCO, we held that a passenger need not establish that a ship owner have actual or constructive notice of a risk-creating condition. But USCO also reaffirmed that whereas here, a plaintiff is relying on a theory of direct liability for maintaining dangerous premises or failing to warn of dangerous conditions, plaintiff must establish notice as part of those claims. Went on to say that this type of case in Holland, where the plaintiff was alleging a puddle of water on a staircase, is one where the plaintiff is limited to a theory of direct liability. And unlike the plaintiff in USCO, Holland did not identify any specific crew member that eventually caused the injury. So in USCO, you have the dancing crew member that drops the passenger, but in Holland, you simply have a puddle of water on a staircase. The 11th Circuit stated that nothing in USCO suggests that Holland could avoid pleading the required elements for direct liability, which includes actual or constructive notice, simply by titling his claims as vicarious liability claims.
Oh,
Now, following the Holland case,
yeah.
district courts started reviewing the allegations to see if actual or
One day at a time.
properly alleged and how vicarious liability comes into play. So one such case is Kendall v. Carnival Court. And in that case, a plaintiff alleged that he tripped over an unmarked, uneven, and unexpected change in elevation along the floor surface on deck one of the ship. And the plaintiff there.
Well, I'm gonna start.
Which included negligent maintenance, negligent failure to correct a known dangerous condition, failure to warn of that condition, and negligent design. So Carnival moved to dismiss the complaint, arguing that the complaint did not sufficiently allege facts that show that Carnival was on actual or constructive notice of this unmarked, uneven, and unexpected change of elevation. And as part of the plaintiff's complaint in that case, it was alleged that there were 6 prior trip and fall incidents involving similar changes in elevation, that conclusively the dangerous condition existed for such an extended time that Carnival should have known of it, and that Carnival violated industry standards relating to similar passenger walkways. So breaking those allegations of actual constructive notice down, as part of the complaint, there are 6 prior trip and fall incidents listed. And here in bold, we have an example of one. So it was alleged that in 2017, a cruise passenger tripped and fell on an uneven or sloped carpeted passenger hallway on the Sunshine. And then reviewing whether plaintiff properly alleged this prior substantially similar incident to overcome the constructive notice, the court said without any specific factual allegations, the court cannot conclude that any of these incidents were substantially similar to this case. First, only one of the prior incidents occurred on the actual vessel. And while that earlier incident occurred on a carpeted surface, there were no other facts to demonstrate that this incident was substantially similar to the one in this case. And then the court listed out a list of questions it had regarding this prior incident that was alleged. Was the dangerous condition similar or same to the one here? Where and how did the prior accident occur? Were there warnings about the change in slope in that prior accident? Did that prior accident occur in a high traffic area? Are there any precautionary actions taken by the defendant in that prior incident? And the list goes on. Now, the other allegation of constructive notice in that case was simply that the condition existed for such a length of time, and that we should have known about it because the condition was in a high traffic area of the ship. And the court said typically this is an argument that's reserved for a transitory substance case. So again, that would be a puddle of water on the floor. But the court said assuming such a theory is proper, the plaintiff has to demonstrate again specific facts regarding how long the dangerous condition existed and basically list out some type of time reference about it. Now, the third allegation of constructive notice was that the condition violated industry standards. The court said the violation of industry standards itself does not constitute notice of a dangerous condition, citing to another case, Francis v. MSC Cruises, and that the complaint here failed to identify which industry standards were violated, how and when the defendant violated them, and what relation to the industry standards this dangerous condition had. So that. Oh.
Can you hear us on the Zoom again?
Yep.
Yes.
Okay, thanks.
All
The
right,
internet went out momentarily. Sorry about that. Cooper, if you want to
yeah.
back it up 30 seconds and.
All right.
Oh, and also, if you're participating via Zoom, could you please mute yourself? We've been a couple of times, people weren't on mute. If you can mute yourself, thanks.
The sound went off when he was saying the third allegation.
Thank you.
Okay. All right, hopefully everyone can hear me and we're back. So just to rewind a little bit, I was discussing the third allegation of constructive notice, which was that defendant had constructive notice of a dangerous condition because of violation of industry standards. So the district court in Kendall said that the violation of industry standards alone does not in and of itself establish a notice of a dangerous condition. That's because the plaintiff failed to identify which industry standards were allegedly violated, how and when the defendant violated them, and what relation these industry standards actually had to the dangerous condition in that case. So in Kendall v. Carnival Court, the district court dismissed that complaint. Now, turning to Spots v. Carnival, this is an example of actual or constructive notice being adequately pled. In Spots, the passenger alleged that he slipped and fell while walking on the Lido deck of a ship, and 5 claims were brought against Carnival, all direct liability claims for negligent maintenance, failure to warn, supervision, negligent design and training. And in that particular case, the plaintiff alleged facts and said there existed a large puddle of water, 2 feet by 25 feet, that had accumulated and remained on the deck throughout the day. The court found adequate allegations of constructive notice. In that complaint, the plaintiff cited 2 prior lawsuits involving slip and falls on the Lido deck of the ship Pride. And in that case, Judge Altman said that the plaintiff's allegations of substantially similar incidents were sufficient. And I haven't listed all the prior incidents, in this PowerPoint presentation, but there was a good description of what had occurred in those prior incidents, and there are also citations to prior lawsuits. So that gives the court some assurance that there is actual prior incidents which are going to put Carnival on constructive notice. So turning to a case with a different factual pattern, Rosenberg v. NCL Bahamas. A passenger on board a ship alleged that he was using a sauna when a jet of steam struck his arm and burned him and caused him to start to fall backwards. He alleged that he sustained some burns on his arm, that he injured his wrist. And counts were brought against the defendants for failure to inspect, maintain, and service the sauna, and for failure to warn of the sauna's condition. And in that case, the defendants moved to dismiss because plaintiff failed to allege any facts to support how they were actually on notice of this dangerous condition with the sauna. In addressing those allegations, the court said, where a plaintiff's pleading could be interchangeably alleged against any cruise line defendant, the plaintiff has failed to adequately state a claim. So you can tell from the outset that this complaint likely did not have any factual allegations regarding actual or constructive notice of the dangerous condition of the sauna. The complaint provided no details that defendants knew or should have known of any malfunction. And the plaintiff provides absolutely no details of complaints or facts specific to the ship, the ship's crew, or even the defendants in support of his allegations. And you can't simply say that there were prior incidents or complaints without backing it up with actual factual allegations regarding those prior incidents or complaints. And also, the plaintiff argued in response to the motion to dismiss that his own allegations regarding his specific incident were enough to put the defendants on notice, which the court said was improper. As part of that complaint, there was also vicarious liability claims alleged, and the court cited to Holland and said that not only does the plaintiff fail to identify any specific crew member whose negligence caused the sauna injury, he fails to specifically allege any negligence by any NCL employee at all. So there, a plaintiff could not avoid pleading elements necessary for direct liability for negligent maintenance and failure to warn by again titling his claims as vicarious liability claims and simply asserting that the defendants are vicariously liable without any evidence of actual or constructive notice. Right. So turning to another recent case, Jones v. Carnival Corporation. In that case, the passenger was returning to the cruise ship after going to Grand Cayman for the day. He was returning via tender vessel, and it was alleged that the weather started to become windy and rainy with the sea being stormy. And while disembarking the tender gangway to get back onto the cruise ship, the plaintiff slipped and fell backwards. And there the plaintiff asserted 4 counts: general negligence, negligent maintenance, negligent failure to warn, and vicarious liability. And the cruise line again moved to dismiss the claims. Now, in that particular case, the court found that direct and vicarious liability claims had properly been pled separately. But the factual allegations for the direct liability claims and vicarious liability claims were identical. So the court said the true dispute was whether the underlying factual allegations supported both direct and vicarious liability claims. Plaintiff argued that defendant was directly liable as a ship owner for its failure to prevent the gangway from becoming slippery, and also that it was vicariously liable for the crew member's failure to reasonably set and secure the gangway. So the Jones court held that these direct liability and vicarious liability counts were duplicative. And that was because, contrary to the plaintiff's representations, the crew member's breach of duty is premised on the same factual allegations that, accepted as true, give rise to defendant's direct liability. Specifically, the complaint alleged that defendants and its crew members breached their respective duties by engaging in 6 identical acts or omissions. So here comes the tension. Defendant is a corporate entity, and since an entity like defendant must almost act exclusively through its agents, the crew members' acts and omissions and defendant's acts are one and the same. Case Dunn versus NCL Bahamas. There, a plaintiff alleged that he tripped over a chair, and after he was being carried by medical staff, a gurney was dropped and he sustained injuries. In that particular case, the plaintiff pled 1 count of negligence against the defendant, but within that single count alleged 28 acts or omissions by the defendant. And the plaintiff also weaved in allegations of actual or constructive notice, and did not name any specific prior incidents. So the court in that case said that it violated the third wheeling category because it did not separate each cause of action into different counts. And it stated that it's not sufficient to cast a wide net of reported breaches and intends to keep one negligence claim afloat. So that complaint suffered from not separating out each cause of action under a separate heading, and then also alleging the facts that you needed to sustain those causes of action. Looking at another case, this was by Chief Judge Altanaga. On Anders, a plaintiff passenger went down a water slide. And then a second passenger went down the water slide and they ended up crashing into each other. Plaintiff asserted one direct negligence claim and one vicarious liability claim for the crew member that was responsible for setting the passengers down the slide. The cruise line moved to dismiss, and upon reviewing the complaint, Judge Altanaga said that the two distinct claims had allegations that were exceedingly similar and also included allegations relevant only to the other claim. So in that case, the direct negligence claim and vicarious liability claim had exceedingly similar allegations, but also had allegations that were supporting the other cause of action. So the court found that the co-mingling was improper, confusing, and violated Rule 10B and required dismissal. The court also said that you can allege a list of failures as part of your general negligence claim. However, in that case, a negligent training claim was contained within that list of failures. The negligent training is a separate cause of action with distinct elements. And because negligent training is a discrete claim, it has to be pled separately. The commingling of allegations of direct and vicarious liability also affected whether the plaintiff had properly pled facts regarding each theory. So the plaintiff in that case set out the duty owed by the defendant, and that defendant breached that duty, rather than alleging that defendant's employees duty to plaintiff, and specifically identifying how defendant's employees breached the duty and how that breach caused plaintiff's injury. So to separate that up a little bit, under direct liability, you're pleading a duty owned by the ship owner to the passenger. You're alleging that Carnival or Royal Caribbean or NCL breached that duty. Whereas with vicarious liability, you're claiming that a particular employee owed a duty to the passenger, the employee breached that duty. So Judge Altanaga went on to say that when shotgun complaints like this are allowed to survive past the pleading stage, all is lost, and soon extended and aims discovery will commence. So the court is attempting to rein in and stop it and nip these complaints in the bud if your facts and your accounts are not going to support ultimately your lawsuit. Now in Finch v. Carnival Corp, a passenger became ill on a vessel and subsequently passed away. And the estate asserted 3 counts of negligence, primarily related to medical care against the cruise line. There again, the defendant moved to dismiss, arguing that the counts were commingled and that there were separate causes of action under each count that needed to be pled separately and distinctly. So the court said here, plaintiff's amended complaint contains 27 alleged breaches of the defendant's duty to provide reasonable medical care. However, several of those alleged breaches constituted elements of other causes of action, which included negligent hiring and training. Paragraph 32, for instance, alleged that the defendant breached its duty to provide reasonable medical care by not having properly trained medical personnel. And then it also listed failures to adequately hire and train medical personnel. So within one paragraph, you potentially have a negligent training claim, negligent hiring and training, a negligent retention training, and you're going to have to plead those separately with the elements that are necessary along with the factual allegations to support those claims. The court said that count 1 epitomized a form of shotgun pleading by alleging that the defendant owed the duty to deceive, and then listing 21 ways in which the defendant breached the duty, and by alleging that these duties were breached inconsistently. The court also addressed count 3 of the complaint. And again, it distinguished negligent hiring, negligent retention, and negligent training as separate causes of action with distinct elements. And citing to other district court cases, it found that the district courts, when all of these claims have been put together under a single count, routinely dismiss this as a shotgun plea. And that was the case here in Finch. So in practice, when you are pleading and submitting a complaint to the court, the best thing to do is look at your causes of action. So if it's a distinct cause of action, list it as a separate count and ask if each cause of action with distinct elements separately pled. And then if you pled the elements, are those elements supported by factual allegations? So do you have some factual heft to what you're claiming, or is it simply you're reciting the legal elements of the claim without any facts? Then the court's going to look at the complaint and see if the facts that you pled are plausible and if it supports your claim. And then separately, what the court's wrestling with is, is a vicarious liability claim proper in a negligent maintenance and negligent failure to warn context? So is vicarious liability going to be proper when a plaintiff is alleging that he slipped and fell in a puddle of water, or when he tripped over a static condition like a threshold that's sticking out? So that's largely, going to be where you land and which judge you're going to be in front of, how they're going to do that vicarious liability claim. I've seen some instances where the court holds a hearing and they will ask the plaintiff's counsel, how is your direct liability claim for negligent maintenance and failure to warn separate and different from your vicarious liability claim? And if you are pleading vicarious liability claim, just be sure to make it distinct and separate from your direct liability claims. So that's something the court is still wrestling with, but I'm sure we'll see more orders on that in the future. So with that, I'm happy to answer any questions or clarify anything.
That was excellent, Cooper. Great job researching that and presenting it for us here today. All right, our next speaker is Jo Colbert Stanley. I got to tell you, I'm excited because her slides are really cool, AI generated. I think you're going to love it. So Jo is a seasoned, salty even, and those are her words, not mine, attorney, arbitrator, and mediator with over 20 years of practice. She currently chairs the Broward County Bar Association Admiralty and Maritime Law Section, and she serves on the Broward County Marine Advisory Committee. She's currently focusing on her ADR career, and she holds a diploma in international maritime arbitration from the Chartered Institute of Arbitrators and is certified arbitrator with the International Yacht Arbitration Council. She is also a panelist with the American Arbitration Association and a proud associate of the College of Commercial Arbitrators, class of 2023 through 2025. Jo is a registered mediator for Florida's Department of Financial Services and a chair qualified public arbitrator for FINRA, the Financial Industry Regulation Authority that oversees brokerage firms and security transactions. She is also the owner and operator of Stanley Yacht Services, a respected yacht management and maintenance company based in Fort Lauderdale, Florida for nearly 20 years. In her spare time, she's pursuing a PhD in conflict analysis and resolution. So without further ado, we are excited to have Jo here to speak on liveries and charters in Florida. Thanks, Jo.
Thank you. Hopefully everyone can hear me okay, and I think we've resolved all of our major technical glitches, at least for now. So yeah, we're going to talk about liveries and charters in Florida. Has the Boating Safety Act related reeled in rogue operators. I was listening to Cooper and I thought he's talking about shotguns. I'm talking about rogue operators, and we've really convinced y'all that it's the wild, wild west out here in the waterways. But let's see what we can talk about with this particular Boating Safety Act, which I will abbreviate as BSA. So the latest FWC, Florida Fishing Wildlife Conservation Commission statistics for 2022, the numbers for 2023 probably won't come out till June. But the latest stats tell us that the number of registered vessels in Florida increased slightly in 2022. Of course, there was a big jump in 2020 during the COVID boating boom, if you will. And so now there's about a little over 1,029,000 registered vessels. Florida leads the nation in registered vessels. There's an estimated additional 1 million of unregistered vessels or non-registered vessels, which are probably your bigger yachts, and so forth. So needless to say, our waterways are congested. More residents and visitors are coming together to use our abundant water resources and enjoying Florida's boating lifestyle. So today we're going to talk about something those visitors and residents love to do, which is rent boats and other water toys and tool around our waterways. More specifically, we're going to talk about, like I said, BSA, which involves liveries and charters in Florida. So let's get to it. About me. So you heard my little slick bio delivered by Thomas. I had requested the full WWE Heroes entrance. I'm very disappointed I didn't get that, but that's fine.
Couldn't get the sound up.
Okay, the sound wasn't working at that time, and the pyrotechnics were banned. But a little bit about me is that, you know, I do own and operate Stanley Yacht Services, which is a yacht management and maintenance company going on about 20 years now, which is a good run. And I also serve on Broward County's Marine Advisory Committee. So you know that, but by way of full disclosure, I also own and operate a charter yacht. Before you ask, she's a 61-foot Hatteras and her name is Freedom. So this topic is very near and dear to my salty heart, and I have some built-in biases that I'm happy to disclose and declare here. So what we're going to talk about today, like I said, BSA, there's also a new proposed bill, SB 30, we'll talk about a little bit. And then if we have time, I want to talk a bit about the DD program. That's bonus content for you. And we'll have a little Q&A, but if you stick through, if you hang out with me till the very end of this presentation, there will be a free charter drawing. So it behooves you to stick around. You have to be here to win it. So good luck to all of you playing along. So the background, and I love these AI generated watercolor paintings of our waterways. There's so many things wrong in this picture, including the half missing swim platform ladder, but that's about accurate for a lot of things I do see on the waterways around Broward County. So the position that Florida has as I said, the leading state in boating also makes it the leading state in fatalities, unfortunately. And so we've had legislative action prompted with a view to enhancing safety. The leading counties, if you're interested, are Monroe, Miami-Dade, and Palm Beach, and Broward has the highest incidence of boating-related accidents. The 2022 BSA, which was came from SB 606, originally sponsored by Senator Ileana Garcia and Representative Adam Botana, addressing some key safety issues. The legislation emerged from, you know, a trio of challenges, according to the proponents, including the just surge of rampant illegal charters, unlicensed crew operations. I know some of you here, I see a lot of familiar, well, names, if not faces, have had to deal with some of these situations. And just significant gaps in safety protocols. So the issues that SB 606 was intending to address weren't just regulatory concerns, but also, directly impacting the safety and integrity of our beloved voting culture. So, Ms. Garcia in particular was, citing loopholes in existing federal regulations, and we'll talk a little bit about that, the loophole that, kind of glaring. And she was seeking to curb the unlicensed crew. I mean, we've got things like, and this picture, like I said, is kind of emblematic of passengers boarding and disembarking vessels via public seawalls where they're trespassing on private property, to pick up charter guests. And the lack of adequate insurance coverage in the event of, accidents. And Botana, meanwhile, Mr. Botana highlighted the need for tighter regulations in light of increased tourism, explaining that he thought the way the law was drafted would help FWC combat bad actors without impeding legitimate business interests, which that's perhaps debatable. So the voting stats indicated there were, I think, about 800 reportable voting incidents. And so reportable includes obviously fatalities, serious bodily injury, property damage of over $2,000 and so forth. And also includes missing persons who are never accounted for in circumstances that suggest death or serious injury. Many of these deaths, according to FWC statistics, are due to victims falling overboard and drowning, which of course many fatalities may have been prevented if victims had worn life jackets. So the inordinate proportion of accidents reported are due to operator inexperience and inattention, or lack of formal voter education. And I should point out that the lack of skill or training isn't necessarily indicative of an increase in number of young or immature operators, as you might expect, but instead it's, according to statistics, the agency has identified that middle-aged or older males with voting experience but no formal training are most likely to be involved in a voting accident, which might surprise some of you. Some of you may not be surprised at all. So the BSA was implemented to give new requirements, as I said, for boat rentals and charter operations. And it was designed to bring clarity to definitions like liveries and seaworthiness, and present, I would say, specific rules for bareboat charters. And that's the loophole that you'll be hearing me talk about, the bareboat loophole. So the bill was hoping to streamline the licensing process and get comprehensive safety education. It flew through committee very quickly when it was presented, and joint bipartisan, and quickly signed by Governor DeSantis, and originally enacted in 2023, January 2022 to be precise. However, there was some controversy over the language. In the final push to draft the language, there was what some are calling a glitch, such that the language for insurance required that the liveries have insurance for themselves, for the livery, and for renters, for $500,000 per individual and $1 million per incident. And needless to say, this threw a lot of red flags and alarms went off. So it created a challenge for rental operators due to limited insurance providers and high costs. So since then, Ms. Garcia and Mr. Botana have worked together to amend the BSA to remove the problematic language, so that now the livery only has to have its own insurance and then offer the same level of insurance to the renter for a fee. If the renter declines to purchase that insurance, there's a big all caps disclaimer that has to be signed saying, I refuse, I understand I'm refusing to get this. And, I understand I may not have any other insurance to cover any damage or injuries and so forth. Kind of like, the way I look at it is kind of like, car rental, right? So let's look at the key provisions in a little bit more detail. Definition of livery. Well, this is the fun one. Charter operators are now facing a new reality regarding this definition. In general, just to talk about the key provisions in general, there's more documentation required, a lot of more paperwork, which is why these papers are flying around in the painting here. The bar's been raised a little bit, in terms of equipment documentation and training and pre-ride instruction and so forth. So it's not just about knowing how to operate a boat, but you've got to understand how to manage emergencies, comprehend the risk associated with boating. It's a move from what we're saying are basic operational skills to a more comprehensive approach to boating safety. So some have said that this industry, the terms liveries and seaworthiness are very loosely interpreted by, especially by rogue operators. So supposedly the act was designed to bring that into clarity, redefining the terms and setting precedents for bareboat and demise charters. And I think the clarity is vital and well-intended for operators and customers to ensure everyone's on the same page. So like I said, the thing that keeps confusing folks is the definition of livery. There's a great, if you are not already a member of it, or if you're like me and don't do Facebook, you won't be a member, but I was able to lurk a little bit. There's a wonderful Facebook community run by Coast Guard officers, Alvaro Ferrando and Rob Parada. They're out of Miami, specifically designed to address small passenger vessels and bareboat charters. And if you just want a good afternoon of entertainment, if you will, if you're like me, find that type of thing entertaining, go on that Facebook and just read the comments. And I have to commend the Coast Guard officers because they have to handle a lot of criticism and clapbacks, as the kids say, about various regulations and enforcement. So in those comments is where you can see anecdotally the confusion about what is a livery, what's not a livery. Just as recently as the day before yesterday, I saw Officer Parada had mentioned, as a reminder, and I'm quoting him, what is not a livery? A rented vessel if the renter is provided a captain, crew, or any type of staff or personnel to operate, oversee, maintain, or manage the vessel. If any crew is provided, these charters are deemed passenger for hire operations. And the reason that's important for the Coast Guard, of course, is because that falls under then the purview of UPBs, the uninspected passenger vessels. So in other words, without using the word bareboat, and the statute is very clear that bareboat is not defined in Florida, but livery is a bareboat charter, okay, or is a providing bareboat charters. Also, a livery is not, very interestingly, a public or private school or post-secondary institution located in Florida. For some reason, we felt the need to include that specific language. A livery also is not a vessel that was not advertised and was loaned to someone who the vessel owner knows, regardless of whether consideration is given. And I'll read that again because that's one of my favorite in terms of making me go, It's not a livery if the vessel was not advertised and was loaned to someone who the vessel owner knows, regardless of whether consideration was given. Okay, A rented vessel, if the renter has provided a captain, crew, or any other type of staff or personnel to operate, oversee, manage, or maintain the vessel, as we said, that's not a livery. So why is that important? Well, obviously, because if you're a livery, these rules apply. And note that to advertise, right, we talked about the carve out, advertising means to describe or draw attention to a vessel and its availability for lease or rental in any medium for the purpose of promoting the lease or rental of the vessel. And again, you know, I would virtually italicize words like draw attention and in any medium. In terms of the definition of advertising, which is if the boat's advertised, that's when it's more likely to fall into the livery cat. These are all, by the way, section 327.54 of Florida statutes, which I don't need to pull up for you guys. You're all very smart lawyers with access to the laws. Okay, so obviously this definition of livery, like I said, it specifically brings bareboat or demise charters under the umbrella of the BSA regulations. And I do think that that could be of consequence, assuming there's enforcement. So seaworthiness. This was an interesting little addition here. What they said is seaworthy means the vessel and all of its parts and equipment, including but not limited to engines, obviously, bilge pumps, obviously. But now there's a focus on kill switches, which if any of you have done any PWC, personal watercraft riding, you know, or smaller boats, the kill switch usually got to attach to your wrist if you're boating responsibly. Obviously if it pulls out, if you fall overboard or you are ejected, and because it's attached to your wrist, it pulls the plug, pulls the key, and disables the vessel. So under the definition of seaworthiness, that kill switch has to be in good operation, reasonably fit for its intended purpose. So you fall under the definition of livery. That means now that you are required to abide by some permit requirements. So starting in January 1, 2023, charter or liveries were required to obtain a special permit from FWC. It's free, so it wasn't another charge or collection or anything like that. And to receive authorization, applicants provide simply evidence of adequate insurance and appropriate safety equipment, life vests and that type of thing, and a list of all vessels offered for charter. Again, like I said, the permit is issued free of charge. It's renewed annually. That said, what's important here is if you don't have the permit and you're operating a livery and you're in violation of this provision and would be charged with a first-degree misdemeanor. And the fines are, I think, up to $1,000. Somewhere it says maybe imprisonment not exceeding 1 year, but there is some penalty provision there for not having the permit. Pre-ride or pre-rental instruction before handing over the keys. Now, under the BSA, the livery or charter operators have to provide training to the rental clients on some newly added, by the way, safety topics, not just about how to drive the boat or operate the wave runner or jet ski. The new instruction covers the dangers of bow riding, which if you guys have seen it, you know it. It's where you sit on the front. It's usually kids too, unfortunately, sit on the front of the bow on the gunnel with your leg dangling over. Very dangerous, but you see it so often up and down the New River in Fort Lauderdale. So this new instruction would talk about the dangers of bow riding or sitting anywhere other than a designated seating area on the vessel. Local knowledge, such as navigational hazards and water depths. Yes, there are sandbars. And boating restriction zones and manatee speeds and so forth. The person delivering this training must also have completed an approved boating safety educating course. That's important as well. Record keeping, now renters have to provide a written statement to back saying that they received the mandated safety lessons. And that document has to be signed by the instructor, must be retained for at least 90 days. And also on that paperwork, you have to include the time of the expected return of the vessel. That's important because if they don't return within, I think it's 4 hours, the livery or renter is required to report to the authorities missing, or failure to return. And these rental agreements have to be retained on file by the charter operator for at least a year. So that those are the record keeping requirements and penalties, like I mentioned, they've increased the non-criminal infraction, they doubled them actually from $50 to $100. And the interesting part, I've got quotes down there, was a direct quote that I took from, again, working on Facebook, but the Coast Guard has, as I said, the group talking about BSA and all of its requirements and implications. And when someone asked, well, is it being enforced? The response from Coast Guard was, well, FWC has jurisdiction. So when I was recently in my capacity as Marine Advisory Committee member at the summit with local stakeholders, including law enforcement personnel and FWC, and I asked about how is enforcement going. There was a silence, I suppose one would describe it, but actually because certain things hadn't been implemented yet, there was a 6-month gap between the enactment of the law and the efforts that FWC was putting in place. So whether or not, and I had a call in to Captain Angela Bryan as well about this, but we weren't able to catch up in time for me to give you a quote from her. But the point being, FWC has jurisdiction over all of this. So who is this intended to impact? We've got, as I said, PWC. Now I'm very meticulous about my words. One of the 4 agreements, right? Personal watercraft, PWC, not jet skis, which are made by Kawasaki, not wave runners, which are made by, I think it's Yamaha. So when we say jet skis, it's like saying Clorox, but we mean bleach. So PWC rentals, pontoon boats, you see a lot of those going up and down the river. In Fort Lauderdale and the ICW, they're very popular. They're easy to not maneuver, I should say that. They're easy to get started and get running. Some of them are electric or they just got one outboard. But like I said, anyone can run one right into another boat. The paddleboard rentals are also included there. Did you know that paddle and human-powered craft, like canoes and kayaks and rowboats and so forth, were involved in 12 accidents in 2022, resulting in 12 fatalities. So that just goes to show you how important it is to have, better safety requirements and instruction for those individuals as well. What might be interesting, for those with the sort of, esoteric or academic mindset is, does this all apply to Boat Setter and Get My Boat and other applications and platforms like that, which if you're not familiar with them, it's kind of like hailing an Uber, but it's a boat. And you can go on these apps, you pick a boat, you put a captain, and off you go. And there's been a lot of discussion about whether or not these BSA requirements apply to Boat Setter. The way it works is like you list your boat on Boat Setter, you provide a list of approved captains to pull from for the person renting, or the renter chooses a captain from the Boat Setter website, and off they go. They meet up wherever the guy picks them up, and they go hang out. So sounds like a bareboat, walks like a bareboat, which would put it under the BSA. So the question is, who has to have all of the insurance and fill out the paperwork and do all of the instruction. But again, I think that's gonna be something perhaps more, debate going on about that in the future. Okay. Waypoints to consider. Did the BSA close the bareboat loophole, as I've been referring to it? So as you know, if the owner doesn't provide a captain or crew, it's a bareboat, right? So in the past, this wasn't really addressed in Florida laws. And technically still isn't, like I said, because specifically bareboat is not defined. But the definition of livery sounds exactly like a bareboat. So while bareboats have avoided some of the more onerous federal regulation, in as much as they're not classified as UPVs, uninspected passenger vessels, so bareboats can have more passengers on board. You don't necessarily even have to have a credentialed mariner and all of these different things. But now there are these state requirements that have come into play. So the question is, has that really, is that going to close the loophole? I think it should. But we'll see. Why were unadvertised boats and ones, that you loan to someone excluded? This one really, really stumps me. And I'll tell you, I went into forensic investigating, deep dive to figure out where that language came from, because something happened as the bill was making its way through its various iterations in the committee. Something happened between February 8th, 2020, that would be 2022, and February 23rd. I don't know what happened in those, 15 days of it, where suddenly this language about if it's not advertised, and it's lent or loaned or offered to a person, then it's, whether regardless of whether there's consideration, it's not a livery. This troubles me a little bit because it sounds like, well, we closed the bareboat loophole by addressing bareboats directly, and calling them liveries. Basically, we've created another weird gray area because, well, maybe everyone's my friend, right? I know once I meet you at the dock and pick you up, we know each other now, right? So you're someone I know. And if I haven't advertised, and nowadays, what's advertising? I mean, if you watch any of these intersection takeovers, where they drag, go around in circles, Fast and Furious. I don't know if any of you have had to deal with that in your towns, but it's getting kind of crazy in South Florida. They advertise, but no one knows where those advertisements are. They know, to meet up at such and such an intersection, and we're going to take it over and do burnouts. So are we offering, like encouraging the sort of subculture, or I don't want to use the term black market, but a sort of hidden shadow platform for advertising, and then we say we know each other and off you go. And now you're again back to being the traditional bareboat, but also no longer covered by the BSA because you're excluded by this weird language that I still don't understand why it was included. So, and in terms of drawing attention to your vessel, I wrote an article about this in Compass Magazine for International Yacht Brokers Association, and I made the comment, perhaps glibly, perhaps too glibly, that maybe, brokers should make sure not to tell their clients, not to hang signs off the side of the rails of their yachts while they're pending sale. Sometimes they'll say available for charter. Well, that's an advertisement, and so it would fall under BSA at this point in time. Anyway, it's just an interesting little quirk to me, interesting to me. And then there is the question about whether or not insurance can even be acquired. Florida is currently not very insurer friendly from the insurer's point of view. And those who have remained in Florida, the premiums are, some would use the term skyrocketing. I personally, we haven't had difficulty getting insurance for our yacht. But getting the charter rider is a different thing, and no one wants to insure bareboats and so forth. And for smaller operators, this might definitely be a prohibitive, hurdle. So again, how is this all working out? We don't know. I do know that, Coast Guard is cracking down on illegal charters and, publicizing their efforts quite loudly, but those are from the UPB standpoint. I'll give a little taste of some of those. So, and these are all fun, if you like these types of things. So this one was LeGrand Blue. This was and most of these, this is a sample of the ones that the US Coast Guard has been publicizing. I got tired after a little while of looking at them. So I just looked at ones like in October, November, December of last year, so very recently. So this one is LeGrand Blue. This October 15th, that's a 66-foot azimuth. You can rent her for $4,000 for 4 hours. Well, maybe once she gets all these violations cleared up. So, and the violations issued, you'll see here are kind of standard ones that the Coast Guard imposes for violations. Again, these are under the UPB regs. Failure to have a COI, certificate of inspection, failure to have a certificate of documentation endorsed for coastwise trade, the big one, especially for the foreign flag vessels. Who haven't gotten the waiver, failure to have a drug and alcohol program, and failure to have type 1 personal flotation devices for the number of passengers on board. Those are very standard violations from the Coast Guard. And as you see here, the penalties for the owners and operators go up to $69,000. And then there's the big one, which is violating the captain of the port order, which can have a mandatory penalty over $100,000. Why I like this little picture of LeGrand Blue is because if you can see, on her port side, wrapped it off, it's another smaller boat with quads. It's got 4 outboards on it and a bunch of people on there. And seems that today was a BOGO, buy one, get one for Coast Guard, because that boat also got ticketed. That's Patsy. Patsy was a taxi as well. Numerous violations, same thing, COI, COD, no drug and alcohol program. And for those of you who don't know about the drug and alcohol program, for those of us who charter, we have a random drug testing program, consortium that you become a member of, and you get randomly drug tested, and you have to identify that and have stickers on your boat showing that you are subject to random drug testing and alcohol program to be in compliance with Coast Guard stuff. So, and this one was interesting also because they failed to have a credentialed mariner on board. Amazes me every time. And they also failed to have a sound producing device, meaning I guess their horn wasn't working. Here's another one, Monument Island. This one, I think, was in November. And again, this one, as you can see, was at night. The giveaway, I think, for Coast Guard here was they didn't have a mast headlight or mast headlight. Flag got racked up a bunch of violations as well. Government cut. This one, I forget when this one happened, but this is in December. Again, here the violations are so numerous, they went to single space in between the listed violations. This one included not having the right type of or number of fire extinguishers on board. So this is just to kind of give you an idea. These are the boats that are just going up and down our rivers and canals and waterways that the Coast Guard. This one was in conjunction with FWC. Remember, FWC now has jurisdiction on the bareboat stuff, right? So this one was in Fisherman's Channel, the Pelican 6, I think this is Pelican 6, and also had failed to have a credentialed mariner captain on board. Then we've got Bass Ferry, Miami Beach. Again, no mariner, no credentialed mariner on board. And double shot was a big one. This one caught a lot of people off guard, or surprised a lot of people because it's such a big boat that you would assume she was in compliance. She's been around. She is 120-foot Technomar. If you're not familiar, it's one of those sexy Italian types. She charters for about $15,000 a day. This happened, I think, just last week that she got pulled over, as they say. Guess what? Didn't have a credentialed mariner on board. How does a 120-foot yacht not have a captain, a licensed captain? I don't know. But here we are. And then this one is my neck of the woods, my stomping grounds right here, this 15th Street boat ramp. Again, here's the pontoon boats that we talked about. Again, no credentialed mariner, not the right flotation or right number of flotation devices. Very interesting on this one was providing materially false information to a federal law enforcement officer during a boarding. We'd love to know what that was. And this one I saved for last because he's my favorite, because he's got his arm. I don't know if you can see it in the picture on those of you on Zoom. Arms outstretched, legs outstretched. He's just like, here we go. You caught me. Failure to have a certificate of inspection, failure to have a drug and alcohol program, and failure to have the required type of personal flotation devices for everyone on board. This would be your Jupiter Inlet. So, has the Boating Safety Act reeled in rogue operators? That was supposedly the question I posed at the outset. Everything I just showed you were instances of the Coast Guard cracking down on violations of uninspected passenger vessel, violations of the UPV regs, because bareboat charters, as I said at the beginning, is kind of the wild west of boating, and it's usually the Coast Guard saying, no, this is not a bareboat charter. You don't meet the 7 requirements of a bareboat charter, therefore you're UPV and all of these regulations apply. Because what charter operators were trying to do is say, oh, it's a bareboat, so I can have as many passengers as I want and all of these different things. But the minute that the Coast Guard realizes that the captain was paid for by someone other than the charterer, the person on board, and was provided by the owner of the yacht, that immediately takes it out of the bareboat, or out of the bareboat category. So usually what we get is the Coast Guard saying, no, you're not a bareboat. You are a UPV, and therefore you're in violation of all of these federal regulations. So are we going to get to a place where they go, okay, and even if you are a bareboat, let me see your paperwork. Let me see your proof of insurance. Let me see your state voter ID card and all of that. Remember, by the Coast Guard's own statement, FWC has jurisdiction. So there are joint task forces currently patrolling our waters. For example, Gulf Coast had a recent task force operation where these agencies work together and crack down. So technically you can get you either way, right? You're either UPV or you're bareboat. And that's what I'd like to see. Are more of those types of efforts that I think would perhaps help to close the bareboat loophole. And if you all were here in person, or a little more easy, I'd ask you guys, what did you think needed to be done on this? But wait, there's more. So not to stop at just the BSA, Senator Garcia, I mean, she really is a boating safety advocate. She continues her efforts now with SB 30, which is currently in committee. I think it's on first reading. And it's really targeting BUI, boating under the influence. There were, I think, 600 cases of BUI last in 2022. So this is a welcome step towards more safety. Obviously, alcohol and drug use are, I think the stats I have, play a role about 13% of boating fatalities. So the key points for SB 30 would be Number one, an integration of the boating safety ID and your driver's license. So it would allow us voters to have it on our driver's license. We wouldn't have to carry a separate card. And it would be for no fee. I think currently the DMV can do it for $1. They lose about $1,500 for not charging anymore. But to make it easier to have that document, a symbol on your driver's license showing that you've taken the various courses and achieved the status of a safe boater in Florida. And then there's mandatory insurance for BUI violators. So if you've been convicted of a BUI and another criminal violation happens within 12 months, now you would have to have additional insurance for $100,000 for bodily injury or death and $50,000 for property damage. And operating a vessel without the required insurance would be a second-degree misdemeanor. And then there's the universal boating safety requirement that, I'll tell you, it's been interesting. All persons operating a vessel must have a Florida boating safety identification card regardless of age, effective July 1, 2026. If you know, you know, that is that it used to be or currently is 1988. If you were born after 1988, you had to have the boater safety ID card, having passed the test. So I think that would make you 36 or younger. The SB 30 from Ms. Garcia, Senator Garcia, would be regardless of age, everyone's got to do it. And I'll tell you, the old salts are not happy about this. But again, as we talked about at the beginning, statistics indicate it's not younger boaters causing the accidents. It is the as I refer to them, the cocky and complacent drivers, right? I've been doing this for 40 years. I know what I'm doing, and you know, they get a little more relaxed, shall we say, lackadaisical even. So it's not being well received. Again, this is still a proposed bill, and we'll see how much the flack makes them take out that requirement that it be for all ages. So that's, like I said, in committee, we'll see how it goes. But I wouldn't be doing my job as a member of the Broward County Marine Advisory Committee if I didn't pass along the VTIP. This is your bonus content. VTIP is the voluntary turn-in program. Or vessel turn-in program, excuse me. And please tell your friends and your clients and your neighbors about VTIP. This photograph is one I took. I was doing a delivery from Pompano down to Dania, and the waterways and docks are just cluttered with scenes like this. If you spend any time in the water in Florida, you're gonna see this type of thing far too often. We just recently had a really big one in Fort Lauderdale. The name of the boat was Gallant Lady. It was over 8 feet. It took months to get her removed. She was docked behind a private home, as is many times the case, had a liveaboard, and the owner of the vessel stopped paying the dock rental fee, or dock rent. And it was a lawyer in Louisiana, I believe, and he ultimately declared bankruptcy. And the boat just slowly went into disrepair. It was really a sad, sad sight. And the person living on board had to, you know, leave because, of course, the boat was taking on water. Her parting gift was she graffitied the whole outside of the boat with a lot of less than pleasant things. That's why I didn't include the photograph of Gallant Lady here. And in any event, Gallant Lady has now been removed, but not before leaking gallons and gallons of diesel and oil and stuff into the canal where she was docked and ultimately sank. So aside from, it's a growing problem. And aside from hurricane damage, vessels, you know, like I said, many are just simply being abandoned. And it's a logistical, I'd say a lot of hurdles. It's a quagmire to get these boats removed once they're in this sort of state of disrepair. Miami recently had an Operation Clean Sweep, a 3-day effort. These vessels, and then once they go under, of course, they're a huge hassle and to refloat and remove, but also they're dangerous, right? Because you don't necessarily see them as you're, when you're boating, if they're underwater especially. So VTIP is the FWC's attempt to address this. And the goal is, it's a grant-funded program, the goal being to prevent vessels from becoming derelict, and to get them, to help remove them, when they're at risk. So before they sink, and Angela Better, whose contact info I have, whose contact info I have down there, she and I were chatting yesterday about this. So it's so much easier to remove these vessels before they're underwater, right? Of course, the FWC will remove them and dispose of them free of charge, with no consequences to the owner, no cost, and of course, this reduces taxpayer burden. And the point is, the boat, to qualify to be eligible for the VTIP program, the boat has to not be derelict. It has to be at risk, but not derelict. FWC will work with you, like if you've got a vessel that's derelict, they will help you try to bring it back up to at-risk status, to make it eligible for the free removal and disposal program. But if she's at risk where she's not holding anchor, the hatches won't close, against weather, or she's listing because of water intrusion, or no effective means of propulsion, and so forth. These are the things that can put her into eligibility for free removal. So I encourage everyone the FWC relies on reports and complaints about these. They then go and investigate, try to find the owner. A lot of the problem is not having title to the vessels to be able to remove them, but they do their utmost. They are seeing applications go up. So hopefully if it takes off, and we're really getting into the state of taking care of our waterways and protecting the environment and the safety of our voters at the same time. But at this point, I will entertain any questions if there are any.
So there was a question from Tanya Meister, and that's a question for Joe. I couldn't hear what you said. Are charters booked through Get My Boat considered bareboat or not?
I would argue that they are not. I would also argue that they are.
That's the perfect lawyer answer.
So it depends on if you're asking me as a charter operator or if you're asking me as a Marine Advisory Committee member, actually. The problem with the Get My Boat is that or boats that are, the way they get around a lot of the UPB federal regulation is by not, quote unquote, not providing the captain and crew and telling the passenger or the renter, you get your own captain. That makes it a bareboat. However, 9 times out of 10, the owners of the boats want to tell you who's going to drive their boat, right? I know I do. No, not anyone's getting in my 61-foot hammer and just going off on a bareboat charter. So the minute that the owner wants to provide the captain or pays for the captain, that makes it not a bareboat. So a lot of what these platforms like Get My Boat and Boats that are doing will provide an approved list. And that sort of is supposedly going to put it back into bareboat. But then there's a lot of questioning, which lawyers love, right? It's very fact specific. It's who has ultimate control of the vessel, who controls the crew, who pays the crew, who can the charterer fire the captain and say, get off the boat. If so, that's a bareboat. If not, it's not a bareboat. So your answer, Tanya, is it depends. But I think it's going to be a question of discussion. The question.
Thank you.
You're welcome. Any more questions?
Yeah, I have a question.
Yes, sir.
How do the livery rules apply to boat clubs where people are a member of a club and they can go down and use the boat on Saturday morning?
These are the same types of questions with Get My Boat. So again, if you're just getting the boat and you're the one driving it, that's a bareboat, right? Under the sort of federal guidelines. and in theory, makes it a livery. So in theory, the boat club, I think there's Carefree, there's Freedom, there's a bunch of different boat clubs, should be giving instruction, whether it's dockside or whatever, they should have all of the signage up, talking about the insurance requirements and so forth. In theory,
But if you remember the club, you'd have to go through that instruction every time you use a boat.
in theory.
One other question on the VTIP program. Can someone that's not an owner of a boat that sees a boat that's nearly
Yes.
derelict report it?
So the question was, in case you guys can't hear, on the VTIP program, can someone who's not an owner of a boat report it? Yes, that's what they rely on most of the time. Especially because a lot of these vessels are abandoned, right? The owners are out of town or out of the country even, and they've just left the vessel. And so if you go down the waterways, as I do a lot, you can see vessels that are starting to list. They're still at the dock, they're still there, they look fairly intact, but they're starting to list, they're taking on water, there's an open hatch or growing mold, you sort of start getting the idea that it's being abandoned. Yeah, you can report that to FWC. And again, if you need Angela's contact information, I'm happy to share that again. But what they will do is try to locate the owner. They can't remove it without the owner approving it. And that's what they're trying to get at, is have it removed with the owner's approval before it becomes derelict, which then, sinks at the dock or whatever, then it starts going through a whole other bunch of hoops. Thank you for your question. All right, so if there are no other questions, that takes us to the end. And I just want to say in conclusion that, obviously boating safety is very, very near and dear to my heart as someone who works in the industry, for the industry and around the industry. And I do think that the BSA is and of course the SB 30 that's proposed are significant steps towards, like I said, well-intended towards safer waterways. And I definitely want to see these laws not only be enacted, but to have some teeth, right, and actually be enforced. And I'm hoping we have more joint task force operations to put, some meaning behind the paperwork. So for all of us who cherish our time on the waters, we want to, commit to the safety. So that's all I have for you. Oh, right. How many of you are still here? Because now is the free charter drawing, right? Okay, here you go. You waited, you deserve it. There it is. It's a drawing, a charter, and it's free. You're welcome.
Did you draw that?
No, that's AI. Thank you so much for your time. And there's my contact info. Everyone knows how to get hold of me, and Joe at Law Stanley. And I hope you either learned something or enjoyed the pictures anyway.
All right, let's get started again with our final speaker of the day. Happy to introduce Oleg Otten. So Oleg practices at Robert Allen Law, and he focuses on international business and immigration law. As the yacht visa lawyer, Oleg assists yacht owners with crew visas, yacht brokerages with work visas for non-US brokers and salespeople, and yacht manufacturers with visas and green cards for the engineers, managers, and shipyard workers, as well as with ensuring I-9 compliance. Additionally, Oleg helps clients obtain US visas and green cards based on investments, extraordinary ability, and family ties. Oleg advises yacht manufacturers, yacht brokerages, purchasers, and sellers of pleasure yachts, and trade associations concerning yacht purchase and sale agreements and negotiations, dealer, chartering, and crew agreements, and other transactional and commercial maritime matters. Oleg earned his bachelor's degree in business and finance from Methodist University in North Carolina, and a JD from the University of Miami School of Law. He's a member of the American Immigration Lawyers Association, International Yacht Brokers Association, Russian American Bar Association, and the Federalist Society. Oleg is originally from Omsk, Russia, and he lives in Miami with his wife, Christina Norris, and their 4 children. Without further ado, we are excited to have Oleg here, and thank you, Oleg, for educating us today.
Absolutely. Thank you, Thomas, for the introduction. Good morning, everyone. It seems we're moving pretty fast today, so it's still morning. This slide has been covered, so let's get straight to the substance. When you take a cruise or charter a yacht, you likely notice that the majority of crew members on vessels are not from the United States. When any vessel arrives in the United States, each crew member who is neither a US citizen nor a US resident must have an appropriate visa. For a cruise ship, it typically means a combination C1D visa, which is a combined transit visa, which is C1 portion, and crew member visa, which is D. C1 portion is needed if a crew member is joining a cruise ship in the US as opposed to in some other country. For a private pleasure boat, most commonly, an appropriate visa would be a combination B1, B2 visa, allowing a crew member to both work on a yacht with B1 portion and spend time in the US as a tourist with B2 portion, such as spend his or her days off on shore. Something all of these visas have in common, D and B, is a requirement that a non-citizen does not have any immigrant intent. It means that the non-citizen crew member has a residence in a foreign country that the person has no intention of abandoning. He or she must show an intention to stay in the United States only temporarily. In fact, visas are often denied under a provision of the Immigration and Nationality Act, which states that every person coming to the US on a non-immigrant visa is presumed to have an immigrant intent. So the presumption is that everyone actually wants to violate their status and stay in the US, and the person, the non-immigrant crew member, has to establish to the satisfaction of both a consular officer first at a consulate when trying to obtain a visa, and then secondly of an immigration officer or customs officer at the time of application for admission into the US, that the person is entitled to such non-immigrant status. Such law gives both consular and customs officers a lot of latitude to find that an applicant either intends to immigrate or not going to comply with the terms of the visa, and to deny the visa. To avoid denial, the visitor must establish a residence in a foreign country that he or she does not intend to abandon, the intent to enter the United States for a limited period of time, and that the sole purpose for a visit is to engage in a legitimate activity permitted under the relevant visa. The official crew member visa is D visa. It's typically used by foreign crew members working on board commercial vessels with a set itinerary, such as cruise liners, cargo ships, and international airlines. A crew member must be providing services required for normal operation of the vessel and intend to depart the United States within 29 days. So that's a very significant difference between a D visa and a B visa. The D visa has the strict 29-day limit on presence in the United States. Examples of travel purposes requiring a D visa would be a captain, an engineer, or a deckhand on a cargo ship. Or on a cruise ship, it could be other necessary service staff, such as lifeguards, cooks, waiters, and even beauticians. On a training vessel, it would be a trainee, and also, even though it's not maritime, but on a commercial airline, it would be a pilot and a flight attendant. So those people are necessary on those particular vessels, and that's why they qualify for a D visa. How private yachts differ from commercial vessels for visa purposes? A yacht is considered a recreational vessel when it's primarily used for pleasure by the owner or a guest of the owner. That includes recreational yachts that will be or have been chartered in the US or abroad. A yacht has to be privately owned, but the owner may be either an individual or a holding company, such as a corporation or a limited liability company. Unlike a commercial vessel, a pleasure yacht is a private means of transport with no set itinerary. And a pleasure yacht tends to spend significant time in the US waters, typically longer than the strict 29-day limit on presence in the US under D visa. Because of these differences, private yacht crew members normally receive B1, B2 visa. To qualify for a B1, B2 visa, the person has to be a foreign citizen with a residence abroad, not intending to abandon that residence, and who will work on a private pleasure yacht cruising in the US waters. A major advantage of a B1 visa, as I mentioned before, is that it doesn't have the 29 limit that a D visa has. Also, a crew member with a B1 visa does not need a C1 visa, as many crew members on D visas need, because B1 visa already allows the crew member to transit through the US to join the yacht. If a crew member is planning not only work on the yacht, but also sometimes spend time in the US as a tourist or visitor for pleasure, he or she should also obtain a B2 portion of that visa. There are some other types of maritime occupations for which B1 visa is used besides private pleasure yachts, such as dry dock repairs under warranty while a boat is docked in a US port, being a coasting officer employed when an officer of a foreign vessel is granted home leave and the vessel remains in the US for not longer than 29 days, transiting to the outer continental shelf for oil rig work, and in those cases the B1 crew member, oil rig worker has to have a Coast Guard letter. Some additional rules for the private yacht crew. So to take a little step back, when we get used to the fact that many foreign crew members work on yachts with B1, B2 visa, it's easy to forget that B1, B2 visa in general is a visitor's visa and not a work visa. It normally does not allow anyone to work in the US. Normally, people who want to work in the US have to get one of the work visas, such as H or L or E. So while B1, B2 visa does not allow its holders to technically work in the United States, the federal government created a narrow exception for private pleasure yachts. If all the technicalities are followed correctly, the B1, B2 crew member, we could say, is considered to be working outside of the US. And so doesn't require an actual work visa. For a foreign crew member to be in compliance with his or her B1, B2 immigration status, the crew member must be employed by a foreign entity. And that goes to the point that it's not a work visa, so the crew member cannot be seen as working in the US. So the employer has to be a foreign entity. The payment has to go to a foreign bank account, and it must be made. The payment must be made by a foreign entity as well. And also the crew member has to maintain foreign domicile or residence and sufficient connections to his or her home country, which usually is demonstrated by showing that the crew member owns some property in his or her home country, or has a spouse and children who remain at home while the crew member is temporarily working on a yacht in the US or around the world. And there has to be an intent to return home after temporary work on a yacht. As a practical point, it's important to ensure that a B1, B2 crew member understands who his or her legal employer is. Oftentimes, it's not the direct yacht owner, but it's an overseas staffing company. And the crew member needs to be clear about it, both at the visa interview at the consulate and when entering the country and talking to a customs officer. It's a good idea for to help the crew member that the yacht owner or the employer entity would prepare a letter for the crew member explaining the reason for the visit to the United States and duties of the crew member on the yacht's travel plans, and who exactly pays the crew member. And such letter, the crew member would hand such letter to a consular officer as well as to a customs officer, and it may be the easiest way for the crew member to explain that he or she is coming to the US with correct intentions. Now, so I've been mentioning different government agencies and departments such as Department of State and Customs. So a quick overview of the most relevant agencies. So the US Department of State runs US consulates around the world. And the consulates issue visas to non-citizens and non-residents of the US. The Department of State is not directly connected with the Department of Homeland Security, which is responsible for the internal domestic US immigration enforcement and many other things. So the Department of State issues visas, and the Department of Homeland Security does not. The Department of Homeland Security, on the other hand, can change the foreigner's status in the US, or can also extend it without having to leave the country under certain circumstances. This is an organizational chart of the Department of Homeland Security, and for the relevant agencies, you could see on the bottom, in the bottom row, there is the U.S. Customs and Border Protection (CBP), and there is U.S. Coast Guard, And there is also US Immigration and Customs Enforcement, which hopefully no one has to deal with. And something else which non-immigrants in such situation don't necessarily deal with is US Citizenship and Immigration Services, USCIS. But sometimes crew members have an opportunity to stay and work for an employer in the US permanently, and so such employer would petition for them for their green card through USCIS. About the flag of a private vessel, that has been a big issue for a long time until a few years ago. The B1, B2 private yacht crew members could not work on US flagged vessels. They could only work on foreign flagged vessels, but that's not the case anymore. And a few years ago, the Department of State revised its Foreign Affairs Manual accordingly. So now it states that, and I quote, yacht crew who will provide services on board a recreational vessel who are able to establish that they have a residence abroad which they do not intend to abandon, regardless of the nationality of the yacht, are classifiable as B1. So the yacht's flag doesn't matter anymore, but a US documented vessel must have an American captain, because under a different provision of the law, only a citizen of the United States may serve as master, chief engineer, radio officer, or officer in charge of a deck watch or engineering watch on a documented vessel. A practical point here is, while a B1, B2 crew member may generally work on a US flagged private yacht, there has to be a connection with international arrivals and departures of such yacht. In other words, if a yacht doesn't travel abroad for a very long time, then its activities are purely domestic, and a B1, B2 visa, which is a temporary visa for its crew, becomes inappropriate. The crew would require work authorization for domestic work in the United States in such situations when a yacht doesn't travel in and out of the country. The logic of such international arrivals and departures requirement is connected to the crew members' intent to remain in the US for a limited period of time. There is no bright line test for that, but typically the maximum period of entry on a B1 visa is 6 months. So it's a good idea for the yacht to leave the US and come back at least once every 6 months, ideally more often. Consular officers, for example, are instructed by the Department of State that the key to showing non-immigrant intent by a non-immigrant, such as a crew member, is demonstrating that the intended stay has an actual time limitation and is not indefinite in nature. And the period of time the crew member applicant states as what he or she needs for the visit to the US must be consistent with the purpose of the trip. The applicant also needs to have a specific and realistic plan for the entire period of the contemplated visit. So the applicant needs to provide some sort of itinerary for his or her visit, even if it's not set in stone, but there should be some itinerary or plan on where the yacht will travel during that time. And it's a good idea to have all this information described in the employer's letter, as I mentioned previously, both for a visa interview and for when a crew member is entering the US and has to answer questions of a customs officer. There is a difference between an immigrant status and a visa. So any person, non-citizen and non-permanent resident, can have technically multiple visas in his or her passport. But when you enter the country, you enter only with one particular status. So you have to choose which of those visas you use. And so, for example, multiple visas for crew members could be that someone has a B1, B2 visa, and also at the same time C1D visa. And when entering the US, the crew member or any other non-immigrant may choose the visa he or she wants to use, which will determine that person's immigrant status in the US. And sometimes mistakes happen with this. For example, a crew member is supposed to work on a private boat, but a customs officer admits that person to the US only on the B2 portion of the visa. And anyone can check that after a short period of time after entering the country. It's available. This information is available online. It's just a matter of always checking it. But a person may be admitted in a B2 status. That means that this crew member is not allowed to work on a private yacht in the US. So sometimes another common way how mistakes happen is at the port of entry, there may be a special line for cruise ship crew members. And a crew member of a private yacht may accidentally get into the same line as the cruise employees, and then when he tells the CBP officer that he's a crew member, then he may just get stamped G entry because everyone else in that line was entering with a G visa and status. So there are two main ways to fix that when it happens. The crew member can visit the nearest CBP's deferred inspection office. Normally they are in the international airport. So it should be the one in the area nearest to the office or business, place of business of the employer, or where the yacht is based. And the crew member would need to bring a passport, the most recent I-94, which is the electronic record showing status, and any relevant visa documents. And that CBP's deferred inspection office should be able to fix it in the US without having to leave the country. Sometimes, especially if it's been a while already, it may be more convenient to just exit the country and re-enter, making sure the re-entry is with the correct status. And here, the the letter from the employer is again very helpful because the crew member may not be able to explain clearly that he or she works on a private pleasure yacht as opposed to other types of vessels. And with the letter from the employer, a CBP officer would likely would be less likely to make a mistake. Also, another useful point to remember is it's best for crew members to avoid arriving to US cities that are far away from the coasts, because in many of those places, CBP officers are not familiar with the yacht industry, and they view B visas as just visitors. And when the crew member says that he's going to work on the yacht, those CBP officers mistakenly can deny entry. Visa appointment wait times. That's always a problem, but it became a terrible problem during the COVID pandemic. At some point, all the consulates shut down and no one could get any visas. Then they started gradually reopening, but the wait times were sometimes longer than a year, longer than 2 years. Since then, in the last couple of years, the wait times reduced dramatically, but still in some consulates, crew members have to wait for their appointment for many months. And there is the practical point here is that generally it's a good idea to go to the consulate of your country of nationality for the crew member, but it's not mandatory, and many consulates around the world accept people from other countries for visa interviews. It's important to check with a particular consulate ahead of time. And there are a lot of consulates around the world where wait time is just a few days, while in a consulate, let's say in the Philippines, wait may be a year or longer than a year. So it may be possible and convenient for a particular crew member to go to a consulate in a third country, such as Bahamas or some country in Europe, or any other country where you can check ahead of time the wait time for a visa appointment is short. And it's been a successful strategy with many crew members. So visa interviews normally are very fast. They can be as fast as 5 to 10 minutes. And because of that, the applicants, the crew members, have to be well prepared to explain quickly in just a few words the purpose of their trip, and who the employer is and who will pay them, and have a well-organized set of documents to present to the officer. After the interview, the consular officer could sometimes approve a visa immediately, but often they take a day to think about it. Sometimes it may take longer, but in any case, it's important to keep in mind that when applying for a visa at a consulate, especially in a third country where the crew member is not a citizen, the passport remains at the consulate. And so the crew member needs to be prepared to spend at least a few days or maybe a week in that country waiting for the return of the passport with a visa. And if it's a third country, not the country of citizenship, then it may be more difficult. It requires a hotel, it requires advanced planning. So that's something to keep in mind. And the visa gets printed in the passport and usually mailed to the crew member. There are different reasons why it could be denied. We don't need to go through all of those reasons. It may, in some cases, it may be simply because of the name. The name may trigger some red flag because of different databases, and then the visa application may go into administrative processing, which could be short or could be pretty much indefinite. So when the crew member receives the visa and enters the US through the customs, the customs officer, CBP officer, creates I-94 arrival and departure record, which is in recent years it's been in electronic format. Before it used to be a little piece of paper. And the non-immigrant crew member can remain in the US until the expiration date on I-94. So you can not presume that, let's say, B1 visa is automatically granted for 6 months. It's usually the case, but it's not guaranteed. It's important to check I-94 to see how long the customs officer actually granted that particular person. And also, it's important to retain copies of all of these papers of departure, boarding passes, even of plane tickets. For example, as sort of in the conclusion, I'll describe a case I had some time ago where a non-immigrant was entering and exiting the US on his own yacht, and he was doing everything properly with a B1, B2 visa, but in different ports, they didn't keep records accurately. And so when everything was okay until he needed to go again to a consulate to receive a new visa. So his visa was for either 5 years, 10 years. Those are the typical periods of time for which a visa in a passport is valid. So when it expired, eventually he needed to go to a consulate to apply for a new visa. And the consular officer looked at the CBP records and said that it looked like he violated his time in the US. So instead of exiting as he was supposed to, let's say within 6 months, he stayed for a year. And so visa was denied, but it was a mistake because the records were not kept properly by different agents at some smaller ports. So we were able to successfully get him a visa, because he kept various documents such as plane tickets, different documents showing repairs on the yacht and other personal things in other countries during the time when the consulate thought he was in the US. So that showed that he actually left the US on time. And the frustrating part in that, and the scary part in that, is a person like that, a non-citizen, doesn't have a right to fix those mistakes. It's it's all in the discretion, total discretion of the consular officers. So we were also lucky that there was a consular officer who agreed to take a look and spend 5 or 10 minutes actually looking at the evidence we had and admit that yes, it was a mistake and this person didn't violate anything. And so he was granted another visa, so he was able to continue sailing in and out of Florida on his yacht. So that's all for today. Thank you. If you have any questions, let me know.
Thank you, Oleg. Joe, did you have a question or a comment?
No, it always comes up, of course, about the immigration status. I recently had an offer, if you will, of a relief captain who recently immigrated from Ukraine.
Mhm.
And it's like, well, it seems like a great idea, but first we've got to jump through these loopholes to make sure
Absolutely.
that his paperwork is correct. We opted not to pursue it because it was a little too onerous for us, one vote company. But I think that there is a lot of misunderstanding, especially with the B1, B2. And the boat goes nowhere and stays here in the United States, and you know, that B1, B2 is just taken away.
Right. And misunderstanding is, in fact, not only on the side of the private industry or the crew members, but sometimes also on the part of the government
Of the
officers.
agencies,
Yes,
yeah.
because they also have a lot of turnover, and many of them don't understand all the intricacies because very few of them are lawyers, so they just get very quick training on
Right.
basics. And especially if it's an officer not in Miami or Fort Lauderdale, but let's say in Detroit or somewhere in Nebraska, those officers maybe have never dealt with crew members. And so if they hear that a person with B1, B2 visa plans to work on the yacht,
They're confused.
they immediately think that this person just declared intent to violate the status and to work in the US.
Scary.
Yeah.
Great.
Any other questions from the group for Oleg? That was fantastic and made me realize how truly little I know about immigration law. So certainly a niche field. Thanks, that was wonderful. Do you want to, if you don't mind, just stop the share of your screen and we can take final questions? That one there. Perfect. Well, thank you to all of you for joining us today.